Okay, we're going to read the overview of real property. And in brief, what this is law of real property centers on a person's interest in land, which may be as great as full ownership or as small as a right to enter. It governs how the land and those interests are acquired and granted. Bought and sold, rented and leased, and used as security for debts. Interest in land arise through express creation, i.e., by deed, will, or mortgage, an operation of law, for example, through adverse possession. Realty may be owned by one individual or several, and an interest may become possessory at once or in the future. However, when multiple parties claim conflicting interests in land, recording statutes dictate who will prevail. Real property law also governs items so affixed to the land that they are considered realty, i.e., fixtures, and sets forth rights and responsibilities regarding the use of water. What interest is involved? Freeholds. Present and future possessory interests. Note, these interests are covered in detail in present estates and future interest materials. Present possessory interests. Indefeasible interests, not subject to early termination, includes fee simple, absolute, and life estates. Defeasible interests allows a fee simple or life estate to be terminated if a stated event occurs, includes fee simple determinable, subject condition subsequent, and subject to executory interests. Future possessory interests, interest retained by the grantor includes reversion, possibility of reverter, and right of entry. Interest created in a transferee includes executory interests, remainders, and class gifts. Rule against perpetuities may apply any future interest that is not certain to vest or fail within a life in being plus 21 years is void. So I understand reversions, possibilities of reverters, right to entry. Those interests created in transferee, they include executory interest, remainders, and class gifts. Remainders is a little bit complex, but indefeasible interest is fee simple, absolute, and life estates. Defeasible interests allow a fee simple or life estate to be terminated if stated event occurs, and this includes the fee simple determinable subject to comma. Another type is the subject to condition subsequent, and lastly is the subject to executory interest. So, leasehold interests are talked about right after the rule against perpetuities. So we're really not going into present and future states all that much in this outline. Just an overview. Types of tenancies. Tenancy for years, for a fixed period of time, for example, 10 days, 10 years, created expressly, ends automatically on its termination date, no notice. Periodic tenancy, on the other hand, is for a fixed period that continues for succeeding periods, for example, month to month. They're created expressly or when a lease draws periodic rent payments, terminated on proper notice, appropriate time period. That's your periodic tenancy. A tenancy at will is no stated duration as long as parties desire. They're created expressly. They're terminated on proper notice. Tenancy at severance. You have a holdover doctrine. Tenant remains in possession after tenancy expires. Landlord may evict tenant or create a periodic tenancy by accepting rent. Rights and duties of landlord and tenant governed largely by the lease and tort law. Tenant must pay rent and may not commit waste. Landlord generally must repair, must deliver habitable premises, and may not interfere with tenant's possession. Both parties generally may assign their interests, transferring the entire term, and tenants may also sublease, retaining part of the term. Non-possessory interests are easements, affirmative easements, the right to use someone else's land. Negative easement is the right to prevent something on another's land. And this is in the non-possessory interest section. But we're just speeding right through this. Easement appurtenant involves two tracts of land. The dominant parcel has the benefit, which runs to grantees. The servient parcel has the burden, which runs to grantees with notice. Easement in gross. What is that? Involves one tract of land. Yeah. Right. So it's basically the servient parcel, which has the burden, and people that own the right to use that land don't necessarily have to own adjacent property. Creation of easements, express grant or reservation. The statute of frauds applies to that. An oral grant creates a license, which is not an interest in land. Implication is by operation of law, by use existing before a tract was divided, by necessity for a landlocked parcel. That's the two types of implication, by operation of law. Prescription, acquired through adverse, open, and notorious, and continuous use for the statutory period. Prescription, acquired through adverse, open, and notorious, and continuous use for the statutory period. Termination of easements. So that would be easements by express grant, reservation, implication, and prescription. I think they've called it end cramp before. So the E is express grant, N is necessity, D is, or is this the, that's the destruction of easement. Sorry. So the creation of easements is grant, implication, necessity, prescription. Probably like trying to think of what the mnemonic is. I don't have one off the top of my head. Prescription, again, is acquired through adverse, open, and notorious and continuous use for the statutory period. Termination of easements can end a stated condition, unity of ownership between easement and servient estate, abandonment, estoppel, prescription, necessity, release, and condemnation. So that's your end cramp. E for estoppel, N for necessity, D for destruction, C for probably condemnation or condition, perhaps under granted express grant created easement, and cramp. R is in release, A as in abandonment, M as in merger, and P as in prescription. And they don't have merger in here. Would they have a stated condition, unity of ownership, that's merger, between easement and servient estate, abandonment, estoppel, prescription, necessity, release, and condemnation. A profit is a right to enter another's land to remove products of the soil. Real covenants run with the land at law, and written promises to do or refrain from doing something on land with the usual remedy of money damages. Requirements for burden to run to later grantees, intent, notice, horizontal privity, vertical privity, touch, and concern. In other words, the mnemonic for real covenants to run with the land is, I think it's which. I think. I forget what the W is. I guess it has to be a writing. Yeah, there has to be a writing. I, intent. T, touch. C, concern. Horizontal privity. Vertical privity, notice. So there's more after which. It's just kind of silly though. Requirements for benefit to run is definitely which, because it doesn't require the vertical privity. It's only requiring the writing, intent, touch, and concern. Although it doesn't have a horizontal privity, it only requires vertical privity. So the burden to run is a little bit more elements than the benefit to run with real covenants. Equitable servitudes. Covenants with equitable remedies. I'm actually going to read these just one more time. A real covenant is a written promise to do or refrain from doing something on the land with usual remedies of money damages. The way equitable servitudes is different is that there's only equitable remedies available. That's the only difference. Back to real covenants. Requirements for the burden to run on the land with the land of the servient estate. You could use that term even though they don't use it here. For the burden on the land to run with the land at law, to later grantees that will come into possession and or ownership of the land, is that there must have been a writing. I'm going to say, even though it's not here, intent, notice, horizontal privity, vertical privity, and touch and concern. Requirements for the benefit to run with the land is the intent, vertical privity, touch, and concern. So what's missing between burden and benefit is horizontal privity and notice. Everything else is the same. Equitable servitudes, very similar. It's just that they only remedies, they're real covenants with equitable remedies. That's kind of the definition. Examples are injunction and specific performance. They're implied from a common scheme for development if notice exists. In the requirements for the burden to run are intent, notice, touch, and concern. Requirements for the benefit to run is intent, touch, and concern. Again, I'm really feeling they're missing the fact that they have to be in writing. But last part here is that equitable defenses apply. For example, unclean hands, estoppel, acquiesce, change neighborhood conditions. How is the interest being acquired? We're on page 4, conveyancing. The statute of fraud applies. It requires signed writing by grantor. In land sale contracts, statute of fraud's exception that no writing is required if the buyer has partially performed through possession, improvement, or payment. Time for performance presumed not of the essence. Marketable title Contracts contain an implied covenant that the seller will deliver free title from an unreasonable risk of litigation at closing, for example, when purchase price and deed are exchanged. That's closing. Deeds must evidence an intent to transfer land and adequately describe the land and parties. Effective on delivery, for example, words or conduct showing the grantor's intent to immediately pass title and acceptance, which is often presumed. The types of the deeds: general warranty deed, covenants against any title defect created by the grantor or prior title holders. There's a special warranty deed, which is covenants against title defects created by the grantor, and a quitclaim deed, which includes no covenants and transfers whatever interest the grantor has. Wills, effective. So wills are another way of conveyancing, and they're effective on the testator's death. If at the testator's death she no longer owns the property that was specifically devised, that gift fails. It is, quote, deemed. If at the testator's death the beneficiary has already died, his gift fails. For example, lapses or might pass to the beneficiary's descendants. Under an anti-lapse statute, if he and the testator were related. Adverse possession. Possessor must show actual entry giving rise to exclusive possession that is open and notorious, adverse and hostile, lacking the owner's permission, in other words, and continuous throughout the statutory period for an ejectment action, which is usually 20 years. The statute does not begin to run if the owner is under a disability to sue when the possession begins. This mnemonic is sometimes COAST, so continuous, open, adverse, so open and notorious, adverse, statutory, probably time and taxes sometimes is relevant. Actual exclusive kind of isn't included in the COAST mnemonic, so it's not the best. I think there's one more mnemonic that is maybe a little bit better. Who will own the interest? Who will hold the interest? Concurrent interests. All co-tenants share the right of possession and enjoyment of the property. Joint tenants, two or more co-tenants with right of survivorship, i.e., the dead co-tenant's share passes to the remaining co-tenants. Tenants by the entirety, two spouses with rights of survivorship, created expressly or presumed in some states by a grant to spouses severed by divorce. Tenants in common, two or more co-tenants, no right of survivorship, created by the severance of the above tenancies, and default co-tenancy created if nothing else was specified. There's a couple of things missing in this outline. So the first thing I'm going to say is that they did it kind of backwards. Usually you would start by like tenants of the entirety. So they have to have at least the 4 unities of time, title, instrument, and possession. But with tenants in the entirety, they also need to be married. Joint tenants require those 4 unities. And generally, you need them to elect that they want right of survivorship. And then joint tenancy is created when right of survivorship isn't specified. It may not need all 4 unities. For instance, so we said time and title and instrument and possession, but interest is one that doesn't get as much as it deserves. So for instance, you could have 3 tenants where one of them owns half and the other owns 25%. So they don't have equal interests. They have equal possession to the whole, but we'll go over that hopefully in the upcoming lecture. The other thing that I feel like is missing is deed covenants. There's like 6 of them. Some of them are present and some of them are future. So you have the covenant of cession, the covenant of assurances against lawsuits. You have further assurances, that's a future one. Quiet enjoyment is a future one. I'm trying to do them in order. So that's like 3 of the 6. I wish it would have given me all 6 of them. Against encumbrances. That's a present interest. We'll see them again, I'm sure. I feel like title is a given, though. Competing interests. Grantor transfers some land more than once. Recording acts protect a bona fide purchaser for value without actual inquiry or record notice of the prior conveyance. And the acronym for bona fide purchaser is BFP. Actual notice is what the grantee actually knows. Inquiry notice is what a reasonable inquiry would have revealed, and record notice is what a search of the real property records would have revealed. Types of recording acts, notice statutes, later BFP wins if earlier grant was not recorded. Race notice statutes, later BFP wins only if she records before the earlier grantee records. Race statutes, the first to record wins. Actual notice is irrelevant. Is the land subject, and those are your recording acts. Is the land subject to a security interest? And you have mortgages, land is collateral for a debt. I have learned that there must be a writing for a mortgage. Theories of title. Lien theory. Mortgagee holds a security interest only. In title theory states, mortgagee holds title until mortgage is satisfied. So therefore, I think it's safe to say that if you're in a lien theory state and the mortgagee is holding only a security interest, then if that is by way of one joint tenant with right of survivorship or tenant in common having, actually wouldn't work for tenant common, I think, but if a joint tenant had mortgaged their part of the property, that it would not defeat the joint tenant right of survivorship, because the under the lien theory, the mortgagee holds only a security interest. Whereas in the title theory, when the mortgagee holds title until the mortgage is satisfied, that's going to destroy, like, one joint tenant mortgaging their interest is going to destroy the joint tenancy right of survivorship. That's what happens if you're in a title theory jurisdiction. Then there's an intermediate theory jurisdiction wherein the mortgagee holds title only after default. If mortgager transfers mortgage land, grantee may agree to assume the mortgage and become primarily liable to pay the mortgage loan. Grantee who does not assume the mortgage is not personally liable for the loan, but may lose the land if the transferor defaults. Foreclosure. After default, property may be sold to satisfy the debt. Does not affect senior interests, and it terminates junior interests that have notice, which it doesn't say here. Junior interests are entitled to any surplus remaining after the foreclosure mortgage is satisfied. The mortgager may redeem the land by paying the amount due. If there is a deficiency, mortgagee can sue mortgagor if foreclosure sale proceeds do not satisfy the mortgage debt. That's for a deficiency judgment. Other security interest is your deed of trust, which is similar to a mortgage, but a third party trustee forecloses, and in an installment land contract, the seller retains the deed until the buyer pays in full. An absolute deed is treated as an equitable mortgage when given for a debt. In a lease sale back, the court may determine this was a disguised mortgage. Does the land have special characteristics? Fixtures. Fixtures are items so affixed to the land that they become part of the realty. Constructive annexation. Items not physically attached to the lands are fixtures if they are so uniquely adapted to the real estate that it makes no sense to separate them. Example, keys to doors. Common ownership cases. I can't believe fixtures is such a big section. Common ownership cases. Landowner brings chattel onto land. Annexor's objective intent determines whether the items are fixtures. And then divided ownership cases. The landowner does not bring chattel onto land. Items owner can remove it only if this would not leave unrepaired damage to the premises. Water rules vary by state and by source of water. Water courses, rivers, streams, and lakes, groundwater, percolating water from wells, surface water, rainfall, melting snow, seepage, and zoning. Governmental regulations that restrict the use of land. Existing zoning violations render title to land unmarketable, and variance, permission to depart from zoning restriction. That's the overview.